We'll hear from the appellant when you're ready.
Good morning.
Good morning.
I'd like to reserve 5 minutes for rebuttal.
5 minutes will be fine.
So there are two issues insofar as the appellant, Trevor Hill, has. They're listed in our, obviously, in our brief. I would like to address the second issue that we cited in our brief as the first topic of discussion, which relates to whether there was an error in allowing a substitution of an executor in connection with this matter. I think the issue is determined somewhat by the letters testamentary, which are, I think, on one page, page 49 of the technical record, specifically, I think it's volume 1. If the court has an interest in it, I have extra copies of what this one page says, if I may.
Yes. Counsel, do you need to see this, or you got one for her? Thank you. Thank you.
I said 49, it's 39, I stand corrected, for the technical record. So specifically, what this states in pertinent part is, first of all, this is for the Chancery Court for Hamilton County, Tennessee. Apparently there's an issue in the sense that we have a Part 1 and a Part 2 for Chancery Court in Hamilton County. I take the position there's one court in connection with our brief. I think that the adverse party does not, and says there are two courts. The purpose of, but again, with all due respect, I think there's only one court. It's sort of like the Court of Appeals. We may have 3 sections, but it's one court. And so, specifically with regard to the letters testamentary, what we're required to do under Rule 25 is, if there is a suggestion of death, we have 90 days from the date of the suggestion of death upon the record to file a motion for substitution. The letters testamentary in this case are for the year 2019, specifically the 3rd day of May of 2019. And again, it indicates that the above named deceased person, so you have notification of the death of Joanne Jernigan. And specifically, this Chancery Court issued this, and specifically it says that this is a true, full, and correct copy of the letters of testamentary issued in this case. They're in full force and effect, and they'll appear of record in the court's executor bonds and letters record book. I guess there may be an issue as to the rule just uses the term record. Doesn't specify, doesn't define, doesn't tell you what the record means in that context. It is our position that it is in the record of the Hamilton County Chancery Court. Fortuitously, Mr. Martin is the player with regard to being the plaintiff in this action at this point in time, and who is also the trustee of the trust, and is also the executor of the estate. So factually, he's on notice, obviously, of the death. He's on notice of the receipt of the letters of testamentary, and no action was taken until a motion for substitution was done in the year 2022 after a suggestion of death was filed by him. But more than 1,000 days from the date that we have a notification in the issuance of letters testamentary, we now have someone seeking to substitute as an executor. And there was an objection to that. That objection was overruled, and the court made a determination that he could be substituted. And it is for that reason we made this appeal. It's fairly simplistic, and it's fairly straightforward in connection with this. The more involved issue is the Rule 6002 issue in connection with this matter. It is undisputed on the face of the, quote, record in this case, there was not adequate or sufficient notice given for a hearing on a motion for default. Even in the court's opinion in connection with this matter, it's admitted that it was premature. Specifically, what happened was, apparently they filed a motion for default, and there's a standard rule in Hamilton County that it's docketed on a particular day, depending on when you file it, unless you request to docket it on a different day. And it came up on the regular motion docket, depending on how you count and who is counting. It's either a day or 2 days of premature with regard to the notice that's required of 5 days, together with 3 days for mailing, because it was mailed, together with a Good Friday, which was a holiday that was in all of this. So there was no denying, there's no dispute about there was not adequate, sufficient notice. The court did a fairly thorough analysis of
But didn't the court place great emphasis on the fact that your client basically waived that error by not raising it and raising several other motions in the interim?
I don't know. In part, yes, just to your question, she did say that. But with all due respect, if an order is void or a judgment is void.
Well, why is it void? Do you have authority that says it's void?
Well, yes, Frierson and Decker both suggest that. Also, there is a case of N. Ray Campbell that I'm somewhat would cite to you that also says that insufficient notice voids an order as well. That was authored by.
That's true, but I'm not sure that applies to this type of a motion. That's like putting capital punishment as the result of some minor offense.
And I hear the court. I respectfully disagree. I think that it is mandated that you have the sufficient process, and there is case law that supports that we have cited in our brief. And there's case law even after Turner that supports that. For example, the Bosch case, the Bain case, all of those cases support the proposition that I'm suggesting to you that this judgment is void. So, in fact, to further respond to your inquiry, normally a 6002 motion, as everyone knows, is limited to a year, depending on the three categories that are within the rule. This is not one of those, and again, you can, as justice otherwise requires, but in this particular instance, we take the position that it's void, and it remains void.
The trial judge considered it voidable, possibly, but not void.
She did. I'm not disagreeing with your analysis. I disagree with her analysis. That's why I'm standing here. So with respect to that, though, in fairness to her, she also did an alternative portion of her judgment where she actually said and made a determination whether or not there was an exceptional circumstances with regard to this particular issue that she needed to review in order to determine whether or not to allow the order, if it's determined to be void, to be still maintained as void. And she did a characterization of that. And the issue with regard to that it requires a manifestation of assent. It's a two-pronged test. It's a manifestation of assent, and she is suggesting the participation in some proceedings although there's no evidence that there was anything, quote, actually other than silence and maybe just the participation that gives rise to that, because the rule requires, under the restatement, that it be manifest in connection with the proceeding. Second of all, it has to be a substantial interest, a reliance on a particular interest in connection with that. And again, we submit that that's not, her analysis on that is not correct as well. I've run out of time.
You can finish your statement.
Okay, she analyzed reliance upon the actual deceased doing changes to her will and that kind of thing as the substantial interest that there was. But I was going to speak to that.
You have your time for rebuttal. We'll hear from the appellee.
Good morning, Justices. My name is Elizabeth M. Hill with the law firm of Patrick Beard, Shulman, and Jakeway. I represent David Martin. He is the trustee under the joint revocable trust agreement of Claude and Joanne Jernigan. Ms. Jernigan is the grandmother of the defendant Trevor Hill in this case. She was the original judgment creditor, and when she died, her judgment was assigned to Mr. Martin as the trustee. We are here because Trevor Hill seeks to set aside a 13-year-old judgment pursuant to Tennessee Rules Civil Procedure 60.023. As the court knows, this is an exceptional remedy. It's an escape valve that should not easily be opened. The bar is high and the burden is heavy. Mr. Hill borrowed $147,000 from his grandmother to start a restaurant and bar business here in Knoxville. He said he'd get a bank loan and would pay her back quickly. Well, he didn't, and so she had to file suit against him in February of 2012. Mr. Hill was served with process, and he chose not to participate in the litigation. So there was no appearance in any way, and Ms. Jernigan then filed a motion for default against Mr. Hill and served a copy of the motion on Mr. Hill. The hearing was scheduled in accordance with Local Rule 6.02, and Hill did not appear at that hearing.
But was the hearing set a day or two earlier than the rules technically require?
Yes, it was. Due to the Good Friday holiday and the weekends and the fact that service was mailed, there needed to be 8 business days and there were only 6. But there was notice sent, and on the face of the motion, it appeared that notice was sent. There was a certificate of service on Mr. Hill at the address where service had been obtained of the summons. Mr. Hill did not appear at that hearing. Now, at that hearing, the default judgment was not granted. At that hearing, default was entered and a hearing on the damages set for a future date. And
Well, there was a default judgment as to liability.
As to liability, there was, Your Honor. He then was sent via certified mail the order setting the hearing for April 30th, 2012, and there is a return of service that he was served with that order on April 19th. So 11 days before the hearing on damages, he did in fact receive notice. He did not appear.
The return of service, what was that, a green card?
It was, Your Honor. Okay. It was a green card. Okay. And I believe that's part of the record. He did not appear at the hearing on damages. He did not file a motion to set aside that judgment. That judgment became final, and it remained final even after Ms. Jernigan recorded the judgment with the Knox County and Hamilton County Register of Deeds offices. She served garnishments at banks where she believed her grandson was banking. Those efforts were unsuccessful, and then she died in 2019. Mr. Martin was appointed as her executor and trustee of her trust. In January of 2022, Martin filed a motion to substitute under Rule 25.01 and a motion to extend the judgment because we were now approaching that 10-year period of time under 69.04. Hill was sent notice of that motion. He did not oppose the motion. He did not appear at the hearing. And so an order was entered extending the judgment and substituting Martin as the creditor. So Martin then took steps to collect. And in taking steps to collect, he pursued Mr. Hill's interest in an LLC known as the Hill LLC, and an interest in Forest Hill Knoxville LLC. And these entities are affiliated with the bar and restaurant that Mr. Hill owns here in Knoxville. And it was only then that Mr. Hill came forward and made an appearance in the lawsuit. And when he made his appearance, he sought to set aside a charging order. He didn't challenge the underlying judgment, didn't initially challenge the substitution. It wasn't until later that he filed the Rule 60.02 motion to set aside the order of substitution and extend the judgment. And the court denied that motion, and Mr. Hill appealed, posting a $300,000 cash bond with the Hamilton County Clerk and Master. Then on the day his appeal brief was due with this court, he for the first time in 2023 argued that the 2012 judgment was invalid due to a procedural flaw. This court remanded, and then the Chancery Court held a hearing on his motion to set aside the underlying judgment, which is the judgment we are here for today. The Chancery Court found that that judgment was valid, that it was not void, rather it had been voidable, and since Mr. Hill failed to present a meritorious defense, it was valid and binding. I'm going to take the issues in different order because I think the issue of whether or not the judgment is void or voidable is a significant issue that the court needs to address. The case of Turner v. Turner, it's a 2015 Tennessee Supreme Court case that addresses voidness. And the Supreme Court has dictated in 2015 that there are only 3 instances where a judgment can be set aside as void. Those instances are when the court lacks subject matter jurisdiction, personal jurisdiction, or the awarded relief is wholly outside the scope of the pleadings. In Turner v. Turner, after making the analysis and determining that there were these 3 instances, that court did not have jurisdiction because it did not have personal jurisdiction, and therefore the judgment was void. And then the court went on to the exceptional circumstances analysis. The Turner v. Turner case cites to Gentry v. Gentry, another Tennessee Supreme Court case from 1996. The Gentry court said that judgments are presumed to be valid, and that presumption is conclusive against collateral attack unless 3 narrow exceptions apply: subject matter jurisdiction, personal jurisdiction, and the judgment's wholly outside of the pleadings. The court made a distinction between a mere erroneous exercise of power granted and the usurpation of a power where none exists. So the trial court in Turner did not have jurisdiction over the person and usurped that power, whereas here we have a court that has the power to enter the judgment for default, but there was this procedural flaw with regards to the notice, making it voidable. The principle that procedural defects preceding a default render a judgment voidable instead of void is recognized not only in Tennessee, but in other states and in the federal courts of Tennessee, and we've cited to those within our brief. Here, where there was a procedural defect in the notice of the motion for default, Mr. Hill could have brought a challenge to that within 1 year after the judgment was entered, but he didn't do that. He's now waited 13 years for this, and is asking this court to set aside a judgment that was entered 13 years earlier. And he's failed to present any meritorious defense.
Is he, and I should know this, but I'm coming up blank, is he claiming excusable neglect or one of the other elements under the Rule 60?
He is not, Your Honor, and of course under Rule 60, that type of a motion would need to be brought within 1 year. And you would have to prove that it wasn't willful.
But his Rule 60 motion is based upon insufficient notice.
It is,
But does that come under any one of the named categories for Rule 60 relief?
I believe that would come up under inadvertence, mistake, neglect, and I think that the law under Turner is that the only thing that makes a judgment void are lack of subject matter jurisdiction, personal jurisdiction, or entry of a judgment wholly outside the pleadings, and that's not what we have here. Now, Mr. Hill has cited to Frierson, Decker, Reynolds, the conservatorship of Campbell case. Those cases all cite to either Frierson or other cases dating back to the case of Cherney v. Cherney. Cherney v. Cherney is a Western Section Court of Appeals case from 1993 where no notice of a application for judgment was given at all to the defendant. Here we have notice, it just wasn't timely. In that case, there was no notice at all. The motion was a motion under Rule 59 as opposed to Rule 60. And at the time, Rule 55.01 only required notice of if an appearance had been made in the case. And the Court of Appeals in Cherney concluded that since husband had made an appearance, he was entitled to notice, and they vacated the judgment. But there was no mention of voidness. That was it was made within 30 days of the judgment, and there was no mention of voidness here. However, in dicta, when addressing whether a meritorious defense was also required to be shown, the Cherney court stated, "We do not believe that a meritorious defense is required where the default judgment was procured in violation of the rules of civil procedure." And that phrase is what has been cited to in these cases that Mr. Hill relies upon. That citation is to a case, Patterson v. Rockwell. In Patterson v. Rockwell, if you look at the holding in that case, that is not what the Patterson v. Rockwell court said. It said that no showing of a meritorious defense is necessary to support a motion to vacate a void judgment by default. So we've got this error in Cherney where the court miscites Patterson v. Rockwell International, and then reliance upon that in these other cases, Frierson and Decker and the conservatorship of Campbell. And again, Patterson was a case under the old Rule 55.01 rule, which did not require notice on a defendant who had not made an appearance. In that case, the court said the defendant had not made an appearance and therefore wasn't entitled to notice. So it doesn't address the issues that we have here. It did address mistake or inexcusable neglect because it was, again, within a 30-day window after the judgment had been entered where the defendant moved to set aside. What Hill would ask this court to do is to extend the narrow 3 requirements where a court can set aside a judgment as void, and have that include a situation where there is a mere procedural defect in providing notice, and that is not what the case law in Turner and Gentry, and frankly, Mr. Hill has not provided any Tennessee Supreme Court law that would say that a mere procedural flaw allows for a judgment to be set aside as void. I don't know how much time I have, so I'll jump over to the timing of the substitution. As this court is aware, there are 2 parts in Hamilton County. We have got a Chancery Court Part 1 and Chancery Court Part 2. An estate was opened in Chancery Court Part 2 for Ms. Jernigan, and there were letters testamentary issued to David Martin. Separate and apart from that, in Part 1, we have a judgment from 2012 in favor of Ms. Jernigan against Mr. Hill And that case was closed on the record. It was the 2012 case, judgment had been entered. Aside from the garnishments, there really wasn't much action in that case. And so what Mr. Hill would have this court do is take the entry of letters testamentary in a state case and argue that in any case where the decedent has received a judgment, that would trigger the 90-day substitution requirement in any case where that decedent had had a judgment. He cites to no case law for that position, just simply to Rule 25.01, which states that when there's a substitution of death on the record, that would then trigger the 90-day period for substitution of a party. In looking at Rule 25.01, we think it's clear that the record is the record in the instant case. And what happened here is that after Mr. Martin was appointed and he collected the assets of the estate and obtained the will and was proceeding and carrying out the wishes of the decedent, which included pursuing this judgment, he filed a motion for substitution on the record, and within that 90-day window was substituted and then proceeded to execute on the judgment. I'm out of time.
So the 90 days, the motion for substitution was filed within 90 days of the suggestion of death?
Yes, it actually took place in the same proceeding, Your Honor. So we notified the court that Ms. Jernigan had passed, and then attached letters testamentary and asked the court to substitute the trustee in the place of Ms. Jernigan.
Admittedly, she had been deceased for more than 1,000 days, but no party had filed a suggestion of death.
That's correct, Your Honor. And remember, Mr. Hill was her grandson. He was fully aware of her death. Thank you.
Thank you.
Here from the appellant, rebuttal.
Suggest there's no laws, I would disagree with, in the sense that Rule 34 of the Tennessee Supreme Court rules defines a record in connection with this case. So I would suggest to you that that is the record that we're talking about, which includes Part 1 and Part 2 of Hamilton County Chancery Court. If
But
you read
the probate estate is a separate in rem proceeding from this civil action.
It is, but at the same time, it's a public record. It's not a non-public record.
Yes.
It's a Rule 34. It deals with what constitutes records in the state of Tennessee, and that provides in pertinent part any public record in connection with that, including case records for individual cases. So to suggest that it's not a record, and there's no requirement within that rule that says it has to be a record in that particular part of Chancery Court, because it is Chancery Court. And it may be a separate in rem action in the probate section of Chancery Court, but it's still in Hamilton County Chancery Court. And I don't think that's even necessary if it were in another county. But again, in connection with this, I'm sorry?
If Smith versus Jones is in the Chancery Court of Davidson County and Clement versus Sweeney is in the Chancery Court of Hamilton County, then you would consider both of those a record.
I don't know that I would, but it would be a record, yes.
It sounds like
I don't know what you're talking about, but if you're hypothetical, I'd say yes.
You're mixing an in rem proceeding that happens to be in Chancery Court with a civil action on a debt that's also in Chancery Court.
And again, the point is who is signing, who is receiving the letters of testamentary? David Martin. Yes. He's on notice. He knows, if anyone knows, there's been a suggestion of death in connection with this. And he did not, there's this complaint about, Mr. Hill not doing anything. He did not do anything for 2.5 years about the time that the judgment's going to expire. I will comment upon the factual assertions that have been made by counsel. Again, those are not in the record other than in the way of a complaint. And so with respect to the rules with regard to the 6002, after the Turner case was decided, there have been a number of cases, we cite in our brief, 4 of them, one of them which is Ray Consolidated Campbell, that discuss the voidness of this. I mean, what the appellee is trying to suggest to you is that there is error with respect to pre-existing law with regard to the voidness of this judgment. Well, this Turner did not set just, it was only dealing with jurisdiction. It was a family matter in connection with it. It was not setting forth that these are the only circumstances upon which you can have a void judgment. It doesn't say that. And they're trying to suggest to you that it does say that, and it doesn't say that. And specifically with respect to after that, in Ray Consolidated Campbell, I can read to you what Justice Frierson said in his opinion, which was that our Supreme Court has held that the reasonable time requirement of 6002 does not abrogate the longstanding rule that void judgments may be attacked at any time. That's one of the thoughts that goes to your issue about how many years that it's been. I might tell you Bain, which was decided by Justice Davis in connection with that particular decision, said in a 5.5-year period of time after an order, a motion to set aside is filed with respect to an order of default, was also void and it was overturned. And specifically, with respect to this particular case, it's not the question is not the amount of time. The question is whether or not the order is void, because you may attack it at any time in connection with the voidness of an order. And the question then becomes, why isn't it a void order? Because it says it's a fairly drastic, I mean, there's plenty of case law, including Tennessee Supreme Court cases, that say that's a drastic remedy if you don't give someone sufficient and proper notice of the time for the hearing on the motion for default. That's the purpose of having the 5 days in connection with that particular case. I will tell you, it wasn't 8 business days, it was 8 days that we had to have. So anyway, I'm out of time.
Thanks to counsel for both sides. Have a safe drive back to Chattanooga. Looks like you won't be in rain perhaps this time. Yeah, no promise about the rain.